Good morning, everyone, and welcome to this first panel of the conference. As most of you probably know, I am not Dominique Boulier. Unfortunately, Dominique could not be here with us today because he has a bug, but we wish him a quick recovery, and hopefully he'll be able to join us for the next meeting whenever that one does happen. So my name is Nicolas Vermeys. For those of you whom I haven't had the pleasure of meeting, I am the Associate Director of the Cyberjustice Laboratoire and the Director of the Centre de Recherche en Droit Public here in Montreal. It is my pleasure to host in Dominique's stead this first panel of the conference, as I mentioned. As you can see, if you can count, we only have 3 of the 4 panelists that were announced. Unfortunately, Amy Salazan also had some health issues. In her case, actually, it's her children that caught a virus, and Amy, being the great mother that she is, had to stay home to take care of them. That being said, we are still extremely well served with the 3 panelists that we have, so I will very quickly present them to you. First and foremost, at my left, so your right, is Karine Gentelet. Karine is an associate professor in the Department of Social Sciences at Université du Québec en Outaouais. She is the former, and I'm going to say the best, visiting research chair on artificial intelligence and social justice, at École Normale Supérieure Abionas Abvia. I believe it was in August that her 2-year ended. And she's also an associate member of the Center for Law, Technology, and Society, but more important, she is an ACT researcher. She is the head of Subproject 11, Empowerment of Marginalized Peoples. To Karine's right, or left for you guys, is Érik Bornmann. Érik is the Director of Guided Pathways of Community Legal at Community Legal Education Ontario, i.e. CLEO, for those of you who know the acronym better than the name, as is my case. CLEO, of course, being an ACT partner, and a very active one at that. Previously, Érik was a litigation lawyer at the Community Legal Clinic in Simcoe, Haliburton, Kawartha Lakes, and which is a general service poverty law clinic in Ontario. And last but not least, Heather de Berdt Romilly. Heather, is the Executive Director of the Legal Information Society of Nova Scotia. She is the former Vice President of de Romilly and de Romilly, which was a consulting firm, and also the former president of the Public Legal Education Association of Canada, i.e. PLEAC, which is also an ACT partner. So I am very happy to welcome our 3 panelists. The 3 of them will have a short 15-minute presentation, starting with Karine, after which we will all sit down and discuss and take questions from the audience. While Karine, is setting up, 2 housekeeping notes. Just so you know, for those of you who haven't been in this room before or have forgotten, there are power outlets at your knees everywhere. So if you're looking to plug in your cell phone or your tablet, just know that underneath the table there are outlets. The other thing, just as a reminder, we cannot eat or drink anything but water in this room. It's not because we're mean, it's because, and I kid you not, if you drop an orange juice, I have to call somebody from maintenance because I'm not allowed to pick it up per union rules, and it will cost me $400. So every drop coffee costs me $400, and I love all of you, and I would rather spend that $400 on bringing you all back instead of cleaning the floor. So thank you, and without further ado, I will cede the floor to Karine.
Thank you, Nicolas. I'm happy to be here. Okay. Oh, can you? Okay. I'm not very. I should be, but I'm not very used with a different camera angle. Anyway, Before starting, I would like to begin by acknowledging that we are located on unceded indigenous land. The Kanien'kehá:ka Nation is recognized as the custodian of the lands and water on which we gather today. The Montreal is historically known as a gathering place for many First Nations. Today it is a home to a diverse population of Indigenous and other peoples. We respect the continued connection with the past, present, and future in an ongoing relationship with Indigenous and other people within the Montreal community. Thank you. So, as Nicolas stated, I'm Karine Gentelet. I'm a social scientist, and I work on this on the project led by Karim on how to address access to justice of marginalized groups and communities. Okay. So first of all, and also I forgot, I want to thank the organizers to put this very important conversation and that way to allow us to have the time to have this conversation, and especially I want to thank my team leaders, Jane and Jackie, for their support during the project. So this is basically the question I work on for the past 4 years. How do marginalized group and community address and tackle their justice issue? And how can we engage with them respectfully and use relevant and effective approaches to a better digital access to justice? When I'm sociologist, as mentioned, and for me, access to justice is to be seen as for really deeper and larger than access to courts. Justice is to be understood as social environments, and because social determinants is definitely what determine people access to justice. People live in social systems, act within them, and part of them. They are not simply individuals, and their ways to access to justice through social and community-based means exemplify this. That's why I wanted to, take the lens of the camera the other way and look at what people do and how they address their justice issue. The reason why I'm using social justice instead of only access to justice mean that I have a broader approach to access to justice is because what is needed from my perspective, and I'm glad to hear about my colleague Piana, Professor Piana before, is we need a bottom-up approach to justice. What do individual and civil society organizations do? What are their means to achieve their justice? It means participating, being a social actor and an agent of change, being this is a tough one for a francophone, prioritizing autonomy and self-determination, and as I will try to demonstrate, because I have few slides, they do not frame their reality in terms of mechanism or procedures, but instead in terms of justice and injustice. Okay, the research project. We did internet research of digital and AI initiative deployed locally in different parts of the world, where individual, groups, and community or civil society organization achieve their definition of social justice goal. Historically, it will be historically and socially marginalized and racialized populations that are underrepresented in institutional and decision-making bodies and that experience systemic discrimination. These initiatives are expressing the search for justice and inclusion, self-representation in society, tools allowing for narrative corresponding to their lived reality, renewed interaction, and more equitable and power dynamics and autonomy of actions. I want to showcase, this is the kind of category. Just I want to show. Okay, this is a kind of the geographical example of the initiative that we have collected using an internet research. And this is the kind of what we call stimuli to action, meaning the goal they want to achieve. Okay, she did with okay. And if you can see on the slides, none of them is talking about basically justice, but also access to court. So it's a large issue, but more societal issue, like land claims. I cannot see very well. Okay, crime, disinformation, corruption, extractivism, profiling, violence, feminicide. So it's basically a non-typical judicial objective, but more societal. Okay, the specificity of this digital initiative by and for marginalized group and community. The first one is proximity and horizontal structural governance. Proximity between the groups, the data, and the governance structure. The core thrust of this initiative and their operators are from the community served. So it could be labeled as organic. The principle is self-determination and autonomy and power decision-making processes. There is also an understanding and respect of the issue, needs and values and objective and internal dynamic of the group and the communities served. This initiative also promotes preventing approach, a long-term vision concerning potential societal issue versus reactive approach from the public and private sectors. Most of them are local responses to empirical needs, no over-evaluating of the technological contribution. Decision, it's also focused on decision that are not in line with some institutional actors, meaning that in the decision-making process, the choice they do about the technology or, the mechanism they will put in place, none of the initiative that we talked to, because we did some interview with some of the promoters, for example, none of them include, the fact that they are not in line with some state institution or private institution. They said that they work on their own for their own objectives. So it's not. Maybe at the end of the initiative, when the initiative is fully developed, operational, they will work with the states or other partner, but at the first step, they only work for their needs to address their own needs by themselves. Okay, this digital technology finally allows these communities, which I repeat are marginalized and most of them rationalized, to evolve from subject to social actors. These mediatic tools allow different forms of direct citizen action. Their digital participation and digital action strengthen their empowerment as social actors. Their participation and decision-making processes are undertaken in their own terms and structure according to their needs and to tackle with the challenging they want to address. Such initiatives allow them to take control over decision-making processes and to control representations and narratives of their individual and collective identity. And I insist on the word collective, because most of the time when we talk about access to justice, first of all, we don't take into account the social determinants, economical social determinant, first of all, and also we talk about individual. But in that specific case, this is interesting to note that most of the people we talk to, they define firstly their collective identity. And collective identity means for them the reason why they are in this situation of marginalization. That's why it's very important to acknowledge the collective identity of their needs. And also for them, this initiative is not only a sense to have a better access to justice. For them, access to justice means participate into the society, not only access to court, but also it's a matter of social agency and human dignity. And most of them were very clear about that. So, this digital justice initiative showcases a clear need to consider people agency, people autonomy, and collective willpower. Agency and autonomy, why? Because they are social actors, they are citizens, also because representation in data and digital environments matter. This initiative also acknowledged their active role in this decision-making process and valuing and the mobilization of experimental and field knowledge. And also this initiative respect their value, objective, and the social fabrics of the community being served. Okay, now, and this is the last stage of the project. Now we've done this interview and we did some analysis. We are in the process of proposing some guidelines and recommendations, principle, and we will deliver that on time, hopefully. I have three conditions or principles to foster access to justice. And once again, for us, we need to foster access to social justice before foster access to courts. The first one is importance of data, representation, and visibility issue. This is probably the main issue that people mention to us. We do that. We tackle our own issue is representation. We are invisible into the society because we are marginalized, but also we are not include in the solution because most of our data are invisible also and not processed into the solution. So it means inclusion of historical and systemic background of discrimination and human rights abuses, development of strategy and tools to ensure that proportionate representativity and an urgency to pay attention to data sets and also in the judicial area. And this is mostly the condition that people told us. So it's not what we analyze. This is we taking from the people we talk to. The second condition in inclusion of cultural context and community-based institution. And I do a quick jump on the presentation that we had yesterday about the Justice Bot, and I was thinking about Mary. It was really a fantastic presentation. But I was thinking, okay, if Mary, instead of naming her Mary, can we call her Karima, for example? Karima is a single mom. She has 2 kids under 5. She's the only working at the minimum wage, and she know very well her landlord because she has to deal with him before. As one of her kids has severe asthma, and this severe asthma is because in her apartment there is some mold issue in the kitchen. So she's, and you know, her immigrant status is not that clear. She's very in a precarious situation economically and legally. So she knows that because she also wears a headscarf, she's not very well loved by her or liked by her neighbors. So you know, she already have this historical background of relation between, you know, landlord and neighbors. So when she now facing bedbug issue, how will she react? Will she really use that Justice Bot, knowing that maybe her landlord will be not happy, even she's not going to court, right? But even that the fact that she's using technology to demands for a reparation, for example, it will be interesting. So I think this background needs to be addressed and not only think about individuals if they have no age, no sexual gender or you know, socio-economical background. And the third is also, and my colleague talked about that previously, the third condition will be build digital tool to shift the power dynamic. This is basically the core objective of every initiative that we document. They are doing that because of invisibility, you know, in the data, in the solution, and they want to make sustainable changes in the power dynamic and take the control over their own narrative and their own future. So agency and willpower has to be seen to tackle their own their issue, and most of the solution that are proposed or powered, you know, they don't talk about willpower and shifting power dynamic. It means that also you have to consider autonomy and empowerment, and also I was glad that my colleague talked about that. Governance model that build on inclusion of the self-community in the decision-making process and not just consultation. And also my colleague before talked about, you know, different level of decision-making process and inclusion of the third community. Locally ground by and for tools and governance model as much as possible. No large-scale initiative. This is also what we learned from this research, is most of the initiatives that work were very locally based, managed for the people who they intend to serve. Most of the promoters were from these communities, so they know very well the needs and the issue and the challenges they will have to face, and they stay small, and to growth, maybe they do some collaboration with state institutions, and I'm thinking about this Montreal initiative, and I will be the only one naming it. It's Colors of COVID. It's an initiative that has been deployed during the pandemic from the Black and Brown communities, because they realize the narrative on the media and from the state do not address their issue, and they were, you know, really discriminate into the discursive, the media discursive most of the time, and they say they don't have any data about us, so let's work together, let's work on a community level and collect some data from our own partners. And they built this initiative, and now they're working with Health Canada to you know, include these data into the corpus of Health Canada data. But they work in collaboration, and they control, you know, the collaboration, and they frame it in their own term for their own needs. So it's a very interesting example of empowerment with technology, using technology. Also, my last comment, and I will end on that, is no unilateral and unidimensional processes. I think in that kind of inclusion processes and shifting in power dynamic, we need, and once again, this is from the people we talk to, flexible and ongoing processes with retroaction. This is really clearly something that need to be done. And actually, if you look at the broader picture, because I'm also doing some work on AI regulation and the fact that when a citizen, for example, has their human rights abuses by any kind of technology, digital, AI, whatever, name it, they have no direct recourse and no direct tools that they can, you know, mobilize to say, okay, I have been discriminated by this kind of tool, and I need some reparation, for example. There is clearly nothing of that level for them. So, yeah, that's it. Thank you. And I have more slides, and in the comment I can share it with you.
Heather, if you'll take the podium. Oh, Érik. I have no authority. Do I put your slides up?
Sure. I just have a few.
Yes, sure. Is that okay, of course? Of course. You just
Thanks a lot. So in my brief comments this morning, I'm going to talk about some of the risks of legal AI on marginalized communities from my perspective, working with guided pathways at CLEO. CLEO is a community legal clinic, and it's part of Ontario's legal aid system. So first, I will describe our work and the marginalized communities we serve. Then I will share some examples of how AI might help with our work in improving access to justice. And last, I will discuss some of the key risks for all of us, but especially for marginalized communities. I will also attempt to imagine some broad solutions, but here, certainly with the technology, with respect to the technology, I believe I will learn more from you than you will learn from me. I hope to be like the man in Kafka's Parabel who doesn't answer the questions but passes the test. So, there we go. When we're talking about marginalized communities, so CLEO's perspective is informed by its core public legal education and information mission to serve marginalized communities. So the communities we seek to serve face barriers to accessing justice and the justice system, including income, disability, literacy in terms of reading, writing, and math skills, and also digital literacy and language. They don't speak or understand English or French. When we're talking about marginalized communities in our work and in the legal aid system, we're primarily talking about people living in poverty. However, we know that racialized communities experience ongoing disproportionate levels of poverty. So while it's possible for anyone to experience low income and reduced opportunities, individual and systemic racism plays a significant role in creating disadvantaged conditions and barriers for people who are racialized or indigenous. So our approach to serving marginalized communities is to look at how they experience the law, how they experience law-related problems and go about addressing them, and how public legal information can assist at various points. And there are many ways. And direct-to-public legal applications are one of those ways, one point on a continuum of services. And CLEO has a number of direct-to-public automated legal tools, but I'm going to focus on our guided pathways because we have started to contemplate the utility of incorporating emerging AI applications into these tools. So our guided pathways are decision trees. They guide people to create legal documents, find legal information about their situation. We built our guided pathways to be tools that work for users, that are developed from their point of view, striving to realize 4 guiding principles. So 1, ease of use, and I'm just going to put an asterisk by ease of use and come back to it in a moment. 2, serving a diversity of users, including those who may need someone else to help them use these tools. Robust privacy and security protections, and sustainability over the long term. So using some examples from CLEO's work, I'd like to share ideas for thinking about potential benefits of AI, ideas for how emerging legal AI could address needs and challenges that CLEO faces now in serving marginalized communities with guided pathways. And I will talk about the risks and challenges afterwards. Now, these examples relate to our guided pathways, but they may be applicable to others doing work on online legal tools and contemplating AI. These aren't exhaustive, nor necessarily reflective of the most urgent needs, but they show how we're starting at CLEO to think about AI as helping with access to justice. But I want to preface these examples with a quote from Roger Smith. I don't know if you know Roger Smith. Roger Smith's a UK lawyer who writes about legal tech and access to justice. And he recently commented about legal AI that there is a danger in a field like access to justice of it becoming an answer looking for a question. So in other words, legal AI may not be the best solution to improving access to justice. So that point's well taken, but nevertheless, these examples of available or emerging AI applications that promise to address real-world issues that we face now with our Guided Pathways program. So document assembly. Let's start with document assembly. How can we make it easier for people to fill out the court forms they need and other legal documents? So two of the most challenging aspects for our users, especially those with English and literacy limitations, are drafting narrative, so generating descriptions, and storytelling, drafting, for instance, affidavits that tell a good story, a persuasive story. Both functions now appear to be performed by some AI applications with some degree of skill. I recently watched a demo from a smaller American company that supports large corporations to draft responses to pleadings, recommending relevant pleadings to a claim. So in their words, they have a massive precedent library, you upload the claim, the AI figures out what the claim is and then proposes precedents, adapting the information of the user. It's technology for lawyers, but it could help our family law litigants and small claims court litigants respond to pleadings, drafting better defenses, adapting relevant provisions from a curated precedent library. Storytelling. I was reminded recently, working on an affidavit in support of an emergency motion, a tool that helps people in distress bring an emergency motion at the court, how important it is to tell the story of what happens. That's a very challenging task. And we're now seeing AI. I'm sure all of you saw the Guardian article written by an algorithm. Information on documents. Another challenge is getting people to get the relevant information from their documents, the ability to upload notices, claims, have the relevant data extracted and entered into the guided pathways in the right place would help a lot. In terms of finding information, obviously we all know about chatbots. There's a project in the United States involving the legal aid community down there and Microsoft, trying to build an AI interface that can have a conversation with a person in their own words to find the legal information they need. They haven't done it yet. There's research. We saw yesterday the Justice Bot example using AI to find the case law that's applicable to a person's situation. But we also read about law firms and large corporate litigants using this research technology to understand their adjudicator and find out how the judge they're about to sit before has decided under similar facts and similar issues. I can tell you, going to the landlord and tenant board, as I've done many times in the past, and certainly there are a great many tenants that go there by themselves, it'd be great to know how the adjudicator you have on any given day has ruled on the particular issues of your situation, if you could do that in an easy way. So what's going to happen next? There's also the promise of anticipating legal problems. So in the context of our guided pathways, people have already identified they have a legal issue. They're in there trying to create a court form or other legal document. But there's a potential with AI to think about what might be happening to them next. And here I'm thinking about the research on civil legal needs that talk about these needs cascading. You lose your job, you lose your rental housing, and corny as it may sound, Netflix telling you what you might want to watch next. Like, here's some information that you may need to know soon. And of course, there's evaluation. I see all my Subproject 8 colleagues have absented themselves for this presentation. We're a little behind, but we're catching up. But evaluation, we collect a lot of data. It would be a great assistance if we could use a tool like Microsoft BI or some other gigantic cloud-based artificial intelligence program to extract the insights from the data we have. So there are ideas. There are lots of ideas. But, of course, there are also risks, perhaps some solutions. But putting aside the state of the art for a second, whether legal AI applications can in fact deliver as I've described, and this is still an if, but my sense is it's soon going to be more of a when. There is, of course, a big but. So in considering each of those examples, we face challenges that would negatively impact all of us, but especially marginalized communities. And in particular, each one of those examples presents varying degrees of one or four formidable challenges. So even before we get to how CLEO can use its guiding principles concerning ease of use and how to help all those people who can't even use the technology directly themselves, we have these four issues. So the first one, and you know these well, transparency and accountability. Like, how do we review, how do we ensure ourselves that what this AI application is doing is correct? Our guided pathways are decision trees. They have a knowable number of branches, and we can review the questions along each path. We can review each output. It can take a lawyer days. How do we satisfy ourselves that an AI-driven search, that AI-driven results are correct? Or how do we know who to trust or what to trust? And I know the idea of human in the loop is sometimes mentioned as a safeguard, but as the scale and the complexity of these applications increase, like how can we do this? Of course, privacy and data protection, and every sort of AI idea that's come our way so far has probably stopped here. These examples are derived mostly from privately developed applications. It inevitably means everyone's information, highly sensitive information, needs to be stored on somebody else's system. So how do we ensure it's not being used for some other purpose to the detriment of our users? Security, like as the applications become more complex, like how do we independently verify the security of these applications? And then of course, bias and discrimination. We know about Compass, the ProPublica report. Like, how do we ensure that data isn't being used, or the data that's being used isn't inherently biased? And does this go beyond the data, include the design aspects, questions, choice architecture, structure of the tools themselves? So in a sense, from our perspective, some of the risks, perhaps aside from the reviewability issue, are not new. Many, like privacy and bias, are challenges with legal tech in general and have been, but the stakes seem higher here because the legal AI applications are ostensibly playing a bigger role. And we know, and the stakes for marginalized communities are even higher because they are more vulnerable, and we know they experience the justice system in a different way because of their disadvantage. They will likely end up bumping into one part of the justice system or the other, whether it's about housing, employment, income benefits, or the police. But at the same time, to the point that was made in today's keynote, there may also be a risk as applications improve and find greater real-world application that the access to justice gap is about to grow even greater, that marginalized communities are going to be priced out of new AI-powered tools that prove to serve well more privileged litigants, including governments. So solutions, and I acknowledge there are ideas for addressing the concerns about adverse impacts, reducing these, but these present challenges too. In addition, legal AI, like our decision trees, is a technology that needs to be designed carefully, including to facilitate ease of use, genuinely simplifying complex tasks. What I see from time to time in legal applications is a very complex question presented in a very elegant stylistic way. This is a bit of a simplification, but sometimes it's boiled down to a yes/no question. And essentially all this complexity has been downloaded onto the user and they don't even know it. And so the friction's removed, and in a sense there's a completely different outcome that we're in a negative outcome, but the ease of use box can be ticked if not thought about in particular. So ideally, the solutions would involve marginalized communities and the development and evaluation, user testing in particular. But the bottom line is, in a sense, that legal AI and technology can't be the only solutions, especially for marginalized communities. Other responses are needed too, like training community workers, which is something that CLEO does, training people that work with marginalized communities, and of course ongoing vigilance is required by policymakers, developers, everyone who's involved to ensure that biased social systems and structures aren't just replicated and embedded in the AI. So, in closing, perhaps there's a paradox here. The very people who need assistance to access their legal rights and could benefit from legal AI are the same people who are the most at risk of having their privacy, human rights, and so on negatively impacted through the use of it. And the feasibility and cost of AI-driven applications developed in a way that addresses these concerns, so explainable, transparent AI, privacy protections, guards against biased data, verifiable security, appear to present yet another challenge, perhaps creating a further paradox that the promise of legal tech for access to justice did seem to include this idea of serving more people with less money, but legal AI done right, I think, challenges that assumption. But on the other hand, as these applications improve and the quality of legal advocacy for those who can afford them improves, marginalized communities may also face greater challenges in accessing justice without the benefit of those tools. And hence the working title of my notes is If We Do, If We Don't. So thank you.
Okay, well, I just want to say to this esteemed group that my apologies. I've been doing this research for the last year. I've been so excited to look into more around the impacts of AI on not just marginalized groups, but groups in general, because Legal Information Society of Nova Scotia, we are for everybody. We're not like CLEO, we're not tied to a legal aid plan. So we are in fact there to help the public with their legal information problems. And the reason that I've been particularly interested in this is because we have been chosen by the province of Nova Scotia to develop the province's first family law guided pathway, a kind of do-it-yourself divorce app, which has 66% of our population very excited. And where most of them are self-represented, there's a huge need, and there's far more demand for legal information help than we are able to satisfy through our small resources. And I have to say, we feel very fortunate to be supported by the federal government, a very small grant by the provincial government, and by the Law Foundation of Nova Scotia. So we then pursue project funding to also support our other work. But increasingly, we've identified that it is impossible to do the work we do without developing some sort of guided pathway. And I guess I want to be really careful with this group of, it's not artificial intelligence, and by gum, maybe it's a good thing it isn't from my research. However, our family law do-it-yourself divorce app is going to have a bit more artificial intelligence associated with it. And there's nothing like having a personal interest in something, because I'm going to be the first one to use it when we make it available. So as I've been looking at all of the issues around our data and developing these tools, it's become increasingly clear how little control we have over that information, that we are in effect walking data sets, and we are utterly known at any particular point in time. And so in terms of my comments, this is more or less juxtaposing this notion of protecting people and trying to give them the best legal information to help them, and all about, you know, safety. Like, we want to make sure you're safe and that you're being given a quality kind of support experience, against the reality that we can do that to a certain extent. And then the rest of the world takes over, and all of these players, data brokers, what have you, have their own agendas, and that there's a huge area that's not regulated. So in terms of my comments, I'm going to sort of take us, you might say, from what we're doing at Listens to this kind of higher level view, which highlights relevant research, which I think is very on point with what's being discussed and actually underway here. So of course I looked at what we're doing here first, and then I looked beyond. So just in terms of, oh, here we are, I guess if I do the right clicker, and sorry, I'm gonna just see, what am I doing here? I've got this. I just came out of the hurricane in Atlantic Canada, so I just want to let you know I was a week without power, and I was so happy to get into the hotel here and have lights and a warm shower. So I'm afraid in terms of my presentation, I did all this year's research, but of course I was leaving it until a week before to kind of put it on the slides. So I just want to apologize, because this kind of reflects, you might say, that hurricane effort. But in terms of, just in terms of also backing up, I also just want to make a comment about like who I am, because I am a lawyer, and I worked in the public sector for many years. I was a private practice lawyer, like public sector-wise, for 18 years, and then went in to do international consulting, working with the international financial institutions, and very interesting just on the point of talking about how important governance is to looking at fairness and inequality and accessibility. And just my most recent project before Listens was in Mongolia, their higher reform education expert. And firsthand, you saw how, of course, in seemingly, what would you say, somewhat corrupt systems, they don't want tracking devices. Like artificial intelligence is useful for those who may kind of seek to stay in power. But if you're looking at something as simple as getting an exit visa, well, you're looking at bribing the person so you don't end up going to jail for a period of time so you can't get out of the country. And you realize that in terms of people's happiness, again, coming back to these legal frameworks, it is so entirely framed upon whether they have any confidence that, in fact, there's a fair system or there's any interest in giving them justice. So coming back to Nova Scotia, we understand that the philosophy of many of the people who are coming to seek justice is one where they don't believe they're going to be fairly treated. And that's particularly true for the marginalized communities that come to us with a whole range of intersecting issues. And I guess I would say in reality, we all bring intersecting issues, but it is particularly true of marginalized folks. So in terms of trying to sort that out and build confidence, and this is what at Listens, our mission is access to justice in action, and that sounds really great. Our vision is empowering people to be able to self-identify and give them the tools to help them either prevent, because we're all about the prevention, and that's really nice to see that reflected in this project, but also to solve their legal problems, and we're all about at that early point in time. So I'm just going to mention here, so we have very rudimentary services that people love. They call us on the telephone and they talk. They're anonymous. They don't, we never know who they are. And the demand for that service, we've been around over 40 years, and it is just consistently off the rails in terms of the numbers who call. And of course, more call than can get through, which is unfortunate. So we now have live chat, and we have email responses, and we have a comprehensive website on all areas of the law. Plus, we have a lawyer referral service with lawyers who provide 20-minute or half-hour consultations for a $20 fee that's often waived. And then we have a whole range of other supports, we have the first medical legal health partnerships east of Montreal, and those are so important for the Children's Hospital, for palliative care, and our primary care hospitals. And so the list goes on and on. But what is most important in terms of everything we do, it tends to be about do no harm and focus on people and trying to give them safe environments. So in the creation of our services, we've increasingly developed these web-based apps. And unlike CLEO, we admire CLEO, and CLEO's like our gold standard, and we wish we had their money. So because we don't, we've had to use our own Joomla-based platform, and we've done a really good job of developing apps that can help people on a whole range of things. And we received national recognition from the Canadian Business Quarterly last year for this work. And it was interesting how they framed it, because they came to us. We weren't looking for anything. We couldn't afford to pay them to do a story on us. But they were talking about the recognition of how that helps the Canadian economy. And that kind of comes back to this notion of there being more recognition of the benefit of early intervention and prevention, and the helping of marginalized groups at an early point in time before they may just opt out of the system. Because this is the other thing. What kind of tracking do we do to figure out how many of those individuals just give up in frustration and don't end up participating? So the other aspect, too, of what we're doing at Listens is all about promoting diversity awareness. We have a number of guides that have come out recently talking about embracing LGBTQ+, talking about, that gender identity, all of these issues. They should not matter in terms of everybody matters and how to create inclusive environments. So we're all about the safe at work and trying to build confidence. So that comes back to then, where does AI fit into this whole discussion? And what I think is very interesting in terms of my first couple of slides is that there's a lot of hope, because marginalization is in effect very much a human construct, a human perception, and AI doesn't suffer from that. AI is colorblind, and it's just basically what we put into AI that ends up creating whatever it becomes. So it's really an opportunity to talk about having a system that is free, you might say, of bias and discrimination, if we choose to do that properly. And I did mean to just mention, I think it's very poignant we're having this discussion very close to Ada Lovelace Day on October 11th, and I had no idea that a woman was the prophet of the computer age and the first to publish a computer algorithm 150 years ago. And I think it's really ironic that here we are talking about AI and marginalized groups and women continuing to be put into that, you might say, category for a variety of very good reasons. And isn't it interesting, though, to look historically and see, okay, you know, here's where we've come from, but yet here we are. So, you know, what the heck is going on with this? And the thing is, in terms of the aggregating huge amounts of data, they can be programmed to make our lives better. And this idea of the bots for seniors to be friendly company, to help young kids with learning, I mean, AI has infinite patience. It's wonderful. It will never get pissed off or ticked off or tuned out. I mean, it will be there for you. But in terms of what it's doing, what do we care about as humans that AI can't relate to at this point? Well, it's about making connections. But what's really interesting is when we think about AI, are we putting too much emphasis on the need for the human element? What in fact becomes important in that interaction? And is it really maybe just important that there's a response that we can relate to? And it's interesting in terms of some of the authors on this, like they say, a lot of people talk to their fish, they talk to teddy bears, they feel they're having an important social connection. Well, how important, like in terms of how high level are a lot of our social connections, and how much are we deluding ourselves about how important that human element is? So maybe AI can be great at doing a whole lot more than we even imagine. It's just needing to expand our notion. And this idea that if we're on our way to being transhuman with neural implants, well, that could free us of any binary systems. It could free us of this whole concept of gender inequality. And, you know, it doesn't matter if one person has a neural highway and the other's a hybrid of some kind of biological system. I mean, I think that these are the things that in terms of us thinking about where we're going, it's really important to see where we are, but what we could possibly become. And in terms of access to justice, then how we frame that is so important, because people don't necessarily know anything about right now what they want. They just want a solution to their problem. So maybe a bot that can relate to them and can give back certain information is better than the human who comes. I'm going to say we by and large have had wonderful volunteers working with us, but some are not quite so great on the communication, and it might be that a bot does a lot better job than some of the humans. And we know lawyers are terrible on the communication front by and large. So in terms of looking at the balancing of the risks, the need for humanities to be involved, for marginalized groups to be involved, they have not been. And if we're leaving it to the current architects, and this is thinking primarily in Silicon Valley, then it's just going to keep looking a lot like it does right now. But the point is that it could be an opportunity for us to achieve equality, but we have to figure out, well, what are the problems right now that are preventing it from doing that? And in terms of the monetization, I was interested in asking Hans about JusticeBot. So in terms of the reality of most of these great systems, let's say that we would want to use at some time, that in fact they have to be monetized in some way to make that meaningful, to make it possible. And where we have these opaque terms of use, we can't right now look at trust relationships really being created with users in any way. And there is this potential of AI just increasing and worsening the current inequalities that we're facing. And the idea is whenever humans do get a good idea, we tend to mess it up. So we've got to be really clear about what we're trying to do. And in terms of this Orwellian future, well, when we look at places like China, where already people cannot go into certain stores because the country knows everything about them and can say you're going to be a risk for shoplifting here, or you can't get certain services. So the fact of companies suddenly turning us into data sets and being able to determine our courses of action. And if we move, like with Elon Musk, with brain implants, with people being able to control their movements through thought processes, which is wonderfully liberating for some marginalized groups, people with disabilities. But then what does that mean for the rest of us in terms of if we all have neural implants and then we're totally known, our thoughts are known, there is no privacy in anything that we're doing. It really talks about sort of in terms of that state, well, what kind of state is governing us, and then often merging with corporate interests that we've never voted for and really have no kind of duty of care back to us, at least not at this point in time. So in terms of thinking also about looking from history where the mechanization, it didn't bring much more than misery. I mean, to the human people, it brought a lot of great to the people who owned the factories. So do we want to make sure that in going forward, we're not permitting AI to perpetuate that misery, that it is going to be this positive age that lifts people up from inequality and looks at an equal approach? And so in terms of the two key issues that I had noted in the research was the protection of intimate data and how then algorithms are creating new inequalities that we're not even aware of. And in terms of, for listens, the question to us is, when we're developing these self-help online tools to help people find their own justice, are we in fact creating inequalities through a digital divide and opening users up to unknown risks that we are not able to control? And with the lens that we are all porous, like technology is going right through us. So what does that mean in terms of how we look at developing inclusive AI? And I'll mention it is the ethics of AI decision-making that we need to look at the focus on reducing ethical debt versus technical debt, where it's that speed, we've got to push it out and then let's find out what's wrong and how it's harming people. And that point that we need time for thinking and we need to be able to reflect. And the pushes on AI development right now appear to be primarily that of do it immediately, do it yesterday, and let's not think about it. So in terms of the considerations, and I have more slides here than I'm allowed to go through. So what I'm going to say is I was horrified to find out that there are so many data brokers, that LexisNexis and Thomson Reuters have over 3,000 data points on me, that these dossiers are put together and being sold to the highest bidder. And they cover everything from period apps to personal websites to interactions with friends that we may not even self-declare personal information, but the algorithms are able to pull it out and create these pictures of us. And so in terms of what's happening is that a lot of that pulling out, that is negatively impacting the marginalized groups. It's impacting people of diverse gender and women in particular, and people with health disabilities, where they're being denied coverage, they're being denied employment. And then overlaid with algorithms that are putting sets together that were never humanly constructed. And this is the thing I found most interesting. Here they've been finding that people are being denied loans in online systems because they own a dog and they have a purple hair and this and that. Like the algorithms, they just are finding these patterns. But the point being that the law doesn't protect us on those bases. So in fact, how do we create protections for things that are not even known to us? And this is where the Oxford University researcher, who is referenced in my sources, but she talks about a bias test that she recently developed at Oxford University and is making widely available so that it can at least help organizations figure out, and I guess in all of the labs where work is going on, identify discriminating factors and then test and play with it to try and lessen the discrimination and to help identify where immutable factors may in fact be appropriate, like age, we don't want child labor, but to really give some thoughtful consideration to that and then some transparency to permit it to be openly reviewed and identified and known. So and just in terms of, and talking about like the flaws with the facial and voice recognition, the fact that there are no regulations to take care of us and to protect us sufficiently, and our health legislation is woefully inadequate. And what I thought was most interesting was the idea that we are at a point where interdisciplinary is absolutely necessary. And so the research points to how important this kind of grouping is to get it right, to do it better, and that it's only going to happen, and it hasn't been happening, that this is very much unique. So I think we're kind of at this golden opportunity of learning, and coming back to my personal interest in having our guided family law pathway the best it can be, that it's really important that we've got to get a handle on it, and we've got to do more to promote awareness and recognition so that we're also not making unfair promises to people, and you might say furthering the misery. So anyhow, I don't know if the slides will be shared, but anyhow, I thought that in terms of the sources, the group here might know Susan Schneider, who is in Florida, and Il Seth, who's a neuroscientist who's written a lot, Luke Stark from Western University, Francois Balise, who's at Dell and the Killam Prize winner, Danielle Citron, Sandra Wachter is in Oxford University, and Jeanette Winterston. So anyhow, thank you.
Thank you very much.